Any mention?
My lord.
Yes.
Item number 18, my lord, that is again the same adolescent relationship matter, my lord, postparting. So, my lord, the matter in the division bench is coming somewhere September, my lord. Okay.
Yes, 4 weeks. 4 weeks.
4 weeks, my lord. Obliged.
My lord, I beg to mention item number 9, my lord. I'm praying for 3 weeks' time. Declare, please.
Lordship, I beg to make a mention of item.
The land council petition. List after 2 weeks.
2 weeks, man.
2 weeks. Yes.
Lordship, I beg to make a mention of item 8, Your Lordship. Item 8.
Yes.
Lordship, I'm praying for 2 more weeks accommodation, Your Lordship, in this matter.
I pay for the private respondent. It's an upmanship matter.
Any objection? No objection. No objection.
My friend is for Mr. Day.
Yes. Any objection? This also on request.
Obliged.
Yes.
Lordship, similar prayer for item 13.
Yes. What? Item 13. Same as. Yes.
Hello, Batch, Lordship.
May I please, Lordship, I beg to mention item number 11, Lordship.
Yes.
May this matter take up after 2 weeks, Lordship.
No objection. Yes also. 2 weeks. Yes.
Much obliged, Lordship.
So, Lordship, I beg to mention item 10. Mr. Chanda is not available today, Lordship. Bring for 2 weeks' time.
No objection, Lordship.
Yes. Yes also.
Hello, Lordship.
Yes.
Yes, Your Lordship. Lordship, I beg to mention item number 21. Praying for 2 weeks' time, Your Lordship.
No objection, Your Lordship.
Yes. 21 on prayer made on behalf of the state respondents. Listen matter after 2 weeks. Yes.
Obliged, Your Lordship.
Item number 1, Your Lordship. Item number 1.
Item number 1.
Yes.
The motion.
I would
Wait,
like.
let it be called. Wait, when the matter comes up, when the matter is called, you do not have to mention the part 1 matters. Only hearing matters you mention. Yes.
Lordship, I beg to mention item number 19.
Yes.
I pray for 3 weeks' time, Lordship.
With the petitioner.
Yes, Your Lordship.
Who is the respondent?
Yes, I'm responsible. I'm respondent number 4.
This. 19. 3 weeks.
3 weeks, Lordship.
3 weeks on the prayer of the petitioner. Yes.
Obliged.
Supplementary cause list, item number 1.
Yes.
Lordship, item 1 and 2, there are 2 matters. Praying for quashing of a case registered under section 14A of the Foreigners Act. The petitioner, Lordship, he is a British national having a valid visa, valid passport issued by the United Kingdom. He came on a valid Indian visa to India, Lordship. And in his travels, he has been picked up from Dauki market on the allegation that he is a suspected Bangladeshi national. And he has been put in jail and implicated in this matter. Lordship, in fact, I am informed the charge sheet also has been filed today in the court of Amlarem. The main issue, Lordship, is that there is absolutely no question of the petitioner committing any offence under the Foreigners Act at all. And those documents have also been found to be genuine, the passport and the visa, as verified by the IO, while considering this, the prayer for grant of bail before the trial court. The major concern, Lordship, here is that the visa which has been issued by the Indian government will expire in the month of 11th September 2025. And thereafter, Lordship, if he is still implicated in the case, his visa also will not be renewed or extended, and nor can he go back to his parent country, UK. And in that situation, he will actually become a illegal settler, Lordship.
But then if it is because of some restraint order, I don't think there will be some exemption in that.
Lordship, may kindly see what has happened here. Kindly see page
Now, you said
19.
that matter has been charge sheeted.
Today, I am informed that it has been filed today, the charge sheet, under 14A. Kindly see.
And you have made a valid entry into the country through the proper. Your entry in this country.
Yes, I have entered from the international airport, Lordship.
Yes, what is
Actually, Your Lordship, this gentleman is originally from Bangladesh. Because of the turmoil in Bangladesh, Your Lordship, he got asylum in UK and he got a passport also there, from there. Then he was given a voyage, document for voyage to go all over the world except Bangladesh. Except Bangladesh.
for international travel except Bangladesh? Yes.
But being when he came to Dauki, Your Lordship, he crossed the border and entered Bangladesh to meet his family members. That is the instruction I get here, Your Lordship.
Okay, he crossed over to Bangladesh.
Yes, and which he was not supposed to do, as per his.
But then if he does that,
Then he came back this time, and he was waiting when the BSF found him and picked him up, Your Lordship. So now, Your Lordship, the BSF is respondent number 2, Your Lordship. They have also to be.
but that is all right.
Yes. But this is
But
the.
if a person is holding valid document, why should he suffer that?
But that.
Maybe his
But he was not
entry-
allowed to cross over to Bangladesh, which he did.
But then that will be a violation.
Violation.
Will it be a violation of Indian law?
Though the stipulated period.
Let
was
us assume
issued-
that he crossed over. Let us assume he
Yes.
crossed over.
So he had violated the documents, documents by which he was allowed to move around the world.
Will it be a violation of Indian law?
It could be a violation of Indian law because he,
What is the provision? What will be the appropriate provision? Where it is provided?
in Foreigners Act, Your Lordship, 14A, it says that he cannot enter into any of those areas which is restricted, and his travel documents had restricted him from going over to Bangladesh.
It's okay. See, we do not know. See, his entry
So-
into Bangladesh, which way it's a violation of Foreigners Act.
14A is
14A
entry
does
into
say
India,
that.
Lordship.
14
It does say that. Anyway, Your Lordship, we may be allowed to
You
take
will be
instructions,
reading- you'll be-
and then the
We are
BSF.
not- We are not passing any order right now.
No, Your
It is
Lordship.
for the purpose of
Just for
getting-
that is what it says here, Your Lordship. May kindly see this
I have
page 21, annexure 3, Your Lordship, which they have annexed with the petition. It is from the prosecuting sub-inspector Amla Court, West Giant Hills, dated 2nd July 2025. The incident happened on 1st of July 2025.
you are reading page
21.
Page
Lordship,
21, Your Lordship, which is annexure 3.
page 21. Yes. This is the
travel-
information. The
This is
FIR.
the FIR, Lordship.
FIR, lodging of FIR, this prosecuting inspector says that both were in possession, both the petitioners were in possession of UK passport, and during preliminary questioning, they revealed that they came to India for visit purpose only and further illegally crossed over to Bangladesh to meet their family. BSF party apprehended them when they crossed over to India from Bangladesh and were in search of transportation from Dauki to Shillong.
So that the document which he was holding was not sufficient to allow his entry from Bangladesh to India.
Yes.
Anyway,
I was saying
Now
that I
that
was
is-
picked up from the market, Lordship. There was no question of me going to Bangladesh
this
again,
this
coming
will be a
back to.
factual aspect which we will go into this.
No, I understand that, Lordship.
The Foreigners Act, burden is on you, unlike any other criminal.
Absolutely,
So
Lordship.
that is
Absolutely. Foreigners Act 14A talks about illegal entry in India.
what it's illegal entry.
I have not entered into India illegally, Lordship.
But then if you
But then you went over to Bangladesh and
How
came
will I
back
go to
here.
Bangladesh and
See-
again come back and again go and again come back?
You
Lordship?
to meet your
these are
family.
all
But this is,
factual-
of
these are all
course,
factual aspect. If you are to build a case on the factual aspect, then it will be difficult in court.
No, that is the mere allegation. So let the complainant, I have made them a party also, because this is a mere, they have picked me from the market.
Issue notice, you are issuing notice. But then the thing is that scope is very limited. If you are to say that, because this, what has been pointed out by the
They have been
AG
enlarged on bail.
is
That is the allegation in the
you
FIR.
came from Bangladesh.
No, they
And
say.
your own admission that you are not supposed to go to Bangladesh.
No, they say that I came to India, went to Bangladesh, came back to India, and when I was searching for a cab, they picked me up.
Yes.
That is an absurd allegation, Lordship.
At the moment, they are on bail, Your Lordship.
Lordship, how will I cross the
why
international
absurd
border, come back again into India?
Yes, because
Despite
your entry,
having valid-
the what has been stated is that you went to Bangladesh to meet your family members.
No, Lordship,
Otherwise, you see, you are a Bangladeshi because of the political turmoil.
Correct,
you have been out of the country.
Given the asylum
You
and
got
the-
asylum somewhere. Then you got this thing, Voyager, something sort
got
of
a
like
passport.
Yes, document
permission for
voyage.
international travel except Bangladesh.
Lordship.
Which they
And then
violated. Which they
you came
violated.
here and via.
No, I have never
Otherwise,
gone to
why
Bangladesh,
come to
Lordship.
Tauki?
Now the thing
could
is
have
that
gone anywhere
whether
in the
the
world.
document which you are holding would be sufficient
Lordship.
for, you see, legalizing your entry from Bangladesh to
No,
India.
I am saying
as
that
well
I
as-
have never gone to Bangladesh, Lordship. They picked me from the
which
market.
way you will determine that?
Lordship, if it is also some burden, it was also on the prosecution to show that I have gone to Bangladesh.
See, Foreigners Act is a different thing. You see, and what will happen, what will not happen, that will be at the stage of trial, not here.
No, I
And
understand.
as far as India is concerned, he is a foreigner.
There is a difficulty. You see, the
major
initial
predicament-
impression was that the initial impression which this court was having
Lordship.
till AG pointed out that part, that your entry was legal in the country. So the court failed to understand how you could be treated as a foreigner.
I came from the airport only, Lordship.
That is okay, but then if that is the allegation, that is was not
That is what his complaint
that
states.
you entered Bangladesh and then again came back.
No, that is why the BSF would be in a...
His Bangladesh address there.
That is correct.
Address is, see, there is no dispute to it. He is not disputing.
Bangladesh address.
He is an asylum seeker.
Correct. I got a passport under the convention and I came with a visa to India.
That is,
And
see,
from the
that part
market
is
of
not
Dowki,
true.
I have
Like, the
been
only
picked
thing
up.
is that the sovereign is the fact which seems correct at this stage is that he from India, his entry into India initially was not wrong per se. You see, only thing is that he misutilized his visa and then he went to Bangladesh to meet and then he came back. And while coming back, now that is what from
He
Bangladesh.
was picked up.
That is what the legality of that entry. That is the question. We can confine only to that thing. If you can show that his coming back from Bangladesh also will not be an illegal act, then definitely.
Even if I have gone to Bangladesh, then that itself is illegal. Because my passport issued
It's
by...
okay. So
Yes.
what? See, it is illegal whether it basically violates the Bangladeshi law or not. That we are not
That is a
concerned at
different
all.
issue, Lordship, yes.
We are concerned with our law.
Absolutely, absolutely.
Okay. So that is what. And if you say that your entry is from Bangladesh,
No,
the
I am
second
saying
entry-
that I have never
Your
nowhere
second
near
entry-
Bangladesh.
That is his
Lordship.
version, Your Lordship.
Okay.
But the complaint states otherwise.
Lana Council for the petition, I should not issue. Returnable in 2 weeks. You just take
2 weeks, Your Lordship. We'll take instructions.
Oh, you'll for number 2. Okay, Mr. MS T. Yangi, Leonard A.G. along with MS J.D. Nakande, Leonard G. APS for response number 1. And Dr. Mojika along with MS Sobra, APS for response number 2. And hence no formal notice is called for. The necessary instruction. The respondents shall obtain necessary instruction. The council appearing for the respondents shall obtain necessary instruction before the next date. This after 2 weeks. Yes.
Number 2 is connected, Your Lordship.
Same, the other person.
Number 2
Same order.
motion,
then?
yes.
Your same party is there.
Yes,
Dr.
party
Mojika
for
also
the
will be
same.
there. Number 2. Yes. Same order.
party, same
Number 2.
member.
Yes.
Daily list, item number 1.
Yes. Now somebody was mentioning this item. Yes. Yes, ma'am.
I would like to pray for some time, Your Lordship, since the main conducting counsel is not keeping well.
What is this matter about?
This pertains to the students of the CMJ universities. And the state is added as respondent number 1 and 2. And 3 is UGC and the 4th is CMJ.
Okay. Okay, how much time you want?
2 weeks?
Okay. One prayer made on behalf of the petitioner. One prayer made by Your name, please.
Marina. Marina S. Malsam.
Okay, just note her name. Learned counsel appearing before the petitioner. And this is matter after 2 weeks. Yes.
Item number 2.
Please, my lord.
Yes.
I am for the petitioner. In this matter, an affidavit has been served upon us last evening.
Yes.
The objection of the private respondent, informant.
Yes.
I'll need some time to consider the objections and also seek some instructions. And I must also point out, my lord, this is a matter where we said we'll try and settle the issue considering the facts and the issue involved. There's that Flipkart matter.
Okay, including Mr. Sen.
My lord,
Yes.
my lord.
Yes.
So,
We
some
filed our
settlement.
affidavits, my lord.
You
Some
are
settlement.
you are not settling the matter.
Well, the kind of offer they are making. Well, we are not here for making money. Well, the FIR was filed because genuinely there is a case under 420 made out. Now, my lord, of course, when the offer was made for settlement, my lord, when we talk about settlement here, we're not talking about monetary settlement. But the kind of offer made by them, my lord, calling up my client and saying that we are willing to refund you rupees 5,000, my lord, and just one day before the matter is to be taken up. It's like, my lord, they are taking the matter very lightly. Perhaps, my lord, Flipkart thinks that, my lord, the petitioner is in Shillong, very far corner, and, my lord, they're taking it very.
That's not
It's not the
case,
only, my lord,
You
That's
are
not, that's
expecting
not
some
the
very
case,
big
my lord.
amount.
not an amount, my lord. No, my lord.
No,
We
my lord,
basically are
that's-
reasonable. Even an apology, my lord. If somebody comes down and apologizes to my client, it's a different thing altogether.
So this
They
court,
are,
this court is not there to advise you.
my lord.
But then take into consideration the
My lord,
product.
Absolutely, my lord. This is the reason why, my lord. The reason why the FIR is filed. If lordship will go at through our affidavit, this is not the only instance, my lord. This has happened time and again. It's a big corporation, my lord, my lord, making people, my lord, fooling people. So it's a case of fraud.
Customer for a ride.
My lord, taking customers for a ride. And lordship, the reason why, my lord, it may be a small amount. My lord, they run by volumes. The number of sales they make, my lord, even if it's a small amount, my lord, the kind of profit they make in a month, that's how they run.
Since you have filed the objection,
Even one customer is also very important for them.
matter for hearing then.
My lord,
may I only say this? May I only say this? May I only say this? Well, we made certain without prejudice proposals. Some discussions happened, and as I said, it has not fruitified yet. So I am not saying that I am not going to make further efforts to try and settle this. In the meantime, they filed their objection last evening, which I have received. I'll also list it after 2 weeks. We'll see where the settlement goes. If not, then we argue it out. I did not say that it has not fruitified. I just said fruitified till now.
Okay. We just say, Mr. K.C. Gautam, Learned Counsel appealing for the respondent to submit that the objection in this matter has already been filed. Okay. Mr. Talukdar, Learned Counsel, appealing for the petitioner, seeks some time to go through, seeks some time for going through the objection.
Only the interim may be continued.
Wait. You are allowed? Just don't separate allowed. Then you say as prayed for by the parties, list this matter for hearing after 2 weeks. The interim order, if any, past order shall continue till the next day.
I'm good.
See, why you are just...
we want to settle, my lord. It's not that we don't want to settle. Of course, it's a very small matter. But the thing is that the way they are, my lord,
Yes,
their approach, my lord, is absolutely wrong. Obliged.
Item number 3.
I'm good.
Yes, my lord. My lord, I have filed my counter affidavit producing the service book of the petitioner.
You have filed the counter affidavit.
Yes, my lord. Here, producing the service book.
Yes. You have received copy?
Yes, lordship.
Then what is to be done?
My lord, since the prayer was only to produce the service book, if I may read, it's part of my counter, if I may read, my lord.
May I please, your lordship? I need some more time for instruction, lordship.
What instruction?
Yes, lordship.
To see whether rejoinder is needed.
Yes, lordship.
Let us wait for completion of pleadings. And then only we'll see. What about you?
Lordship, I'll be filing lordship, due to some personal difficulty, I was able.
You will be filing an affidavit. You still want to file an affidavit. Also, the pleading is not complete.
No need, your lordship, but
Anyway, just say MS Obang, learning G appearing for the respondent number 1 to 4.
Number 2, my lord.
Respondent number 1 to
I'll tell you, my lord.
1 to
1 and 4. 1 to 4, my lord.
1 to 4. Oh. Submit that. The counter affidavit on behalf of the said respondents. Oh, counter affidavit on behalf of the said respondents has been filed. Stop. However, Miss E.V. Pasa, learned counsel appearing for the respondent number 5. Praise for grant of some more time for filing counter affidavit. It's a prayer allowed list after 2 weeks.
2 weeks, lordship.
Let them file, then we'll see. You want to file a rejoinder to this, or you'll take a decision?
We will have
Okay,
instruction.
just see. Take instruction and then just.
Must oblige, my lord.
5.
Lordship, here I pray for another 2 weeks time, Lordship, to file the counter, Lordship.
May I
Yes.
please, lordship?
Yes,
We
just.
got the affidavit of respondent number 5, lordship.
Private respondent.
Private respondent, lordship.
Has filed.
Yes, lordship.
Your Lordship, an affidavit has been duly filed on behalf of the respondent number 5, private respondent.
Okay. Your name, please.
This is Bithava.
Yes, Learning Council appearing for the respondent number 5 submits that counter affidavit on behalf of this said respondent has already been filed. Stop. Just say Mr.
1, 2, 3.
Sheikh Learned G. Appearing for the respondent number. Who is 4?
4 is the accountant general, Lordship.
Okay, non-APS. Okay, anyway. There is nothing recorded in the last thing. At least you should say non-APS. It is not noted anywhere. If respondents are there, it should say none. Something we mentioned. It is not reflected anywhere. Whether respondent number 4 earlier entered appearance. Oh, okay. Yes. Yes. What you said? Sansa Sansa. Okay, Mr. Just before that, you say none appears for the rest number 4. Then you say Mr. Sheikh Learned G appearing for rest number 1 to 3. Praise for and granted. How much time? 2 weeks. 2 weeks time for filing counter affidavit. List accordingly. Yes.
Item number 6.
Yes.
This is a DCRG. He was the husband of the petitioner. Husband was working as an UDA in a deficit secondary school, Lordship. So the wife has filed the writ petition.
This
claiming
matter
for,
was in fact listed for.
Yes, Lordship.
But then you were not.
Yeah, Lordship, because I was not. So it can be referred. It can be referred.
Mediation. Who is the other side?
My Lord, I'm appealing for the state. Respondent number 1 to.
Lordship, managing committee also a party, but the copy
They have
is
not entered
served.
appearance.
Yes,
They have not
Lordship.
entered appearance.
No,
till now.
Lordship.
So then we cannot refer
So,
it.
yes, Lordship.
Service is not complete.
Yes, Lordship.
See, ID card has not received in from the
Yes.
number 4.
So that will be hard,
Now,
Lordship.
was there any order directing you to file an affidavit?
So, obviously, Lordship, on the motion stage, Lordship.
No. So, for taking steps is one thing, and for filing affidavit showing the service, completion of
Lordship,
service.
I pray for time, Lordship, for filing the status report, Lordship.
Okay, just say office note indicates that no report of service has arrived from the respondent. Office note indicates there is no report of service upon the respondent. Stop. The petitioner shall verify the status and file an affidavit of service in respect of the said respondent. This after 2 weeks. Yes.
7.
In this matter, my lord, I'll pray for some more time. The problem is this, my lord.
You're appearing for?
I'm appearing for the respondents, my lord. This is about gratuity.
All the respondents?
All the respondents, my lord. I'm praying for some time, my lord. I'm praying at least for 3 weeks' time, my lord.
This is for pending salary of the petitioner.
Yes. You are debarred by the strike to enter.
My lord.
Just one prayer made by Mr. S. Dale, Learned Counsel, appearing for the respondent.
I'm praying for 3 weeks' time, my lord.
She is agreeable. She doesn't oppose.
No, she knows very well, my lord, what we are going through.
3 weeks time is granted.
Hallelujah, bless me.
For filing counter affidavit.
Oh,
Yes.
bless.
Hallelujah.
Hearing, item number 12.
Wait, please, Your Lordship.
Yes.
This is a writ petition against the finding of the BSF Security Court. But I've primarily pleaded 2 grounds for challenging the order. My lord, my main ground is that, my lord, after the BSF court came to a finding and sentenced me for a rigorous imprisonment for a period of 7 years and dismissed me from service, my lord, an opportunity is provided under the law for me to file an appeal before the authorities. My lord, more like a statutory appeal any government employee who can file upon being terminated from service. My lord, that appeal is filed under 107, section 107, clause 2 of the BSF Act.
17.
Sorry, 117, my lord. I beg your pardon. Now, my lord, that appeal is to be decided by the appointing authority. In this case, my lord, that appeal was decided by the chief law officer. So, Lordship was pleased to call for records because records were not before the courts, and I was also given an opportunity to go through the records. My contention of Learned Senior is that the application, the appeal was properly dealt with. But when you go through note sheet number 32, my lord, if the records are there, if the records have been brought,
Just tell us, just if required, you'll go through. Just tell us what is
my,
your
my
finding?
case is, my lord. My case is, my lord.
No, what did you find from the thing?
My lord, no.
See, earlier, what has been
That contention, my lord, my contention that it was signed by the chief law officer, that is right before Lordship. Lordship has seen that also. But Learned Senior had taken a plea that it was properly dealt with.
Yes.
And he bought the internal communication. Now, when we go through the internal communication, my lord, it is very clearly stated final orders may be issued. So, no order, proper order was issued.
Now, final order may be issued in which terms? Like which way?
In connection with my appeal.
That is okay.
So,
If
that
somebody-
particular order.
See, it is not that the authority concerned was to permit merely somebody to pass an order, isn't it?
Exactly.
It was
exactly.
his duty. Is his duty.
It was absolutely his duty.
Where is that?
Well, Lordship will just see that particular. My Learned Senior will produce that. Sheet number 32.
20 onwards. Now, final order may be issued. What does it mean?
20 onwards.
I'm pointing out is this one.
20 onwards.
Can you make an extract of this and supply it to the court?
I can do that.
That will be better if you can make a copy and then just.
For the time being, it is only
You can
one
show
page.
me,
my
show
lord.
us. But then, is it? Are you disputing? Just tell us, was there any order passed by the official who was supposed to?
My lord.
Huh?
He has applied his mind, my lord, on the left hand side, my lord. The Director General.
Final order will be issued.
Before that, the Director General has applied his mind, my lord. He has signed, and he said that it's a final order.
Now, this is para 67, isn't it, of the note sheet?
My lord, para
Okay,
67.
okay.
I'm talking about
So
para 67.
himself, the Director General has taken a decision by himself, isn't it?
My lord.
That is okay.
No, my lord. That is not a decision, my lord. The decision should have been, my lord, the one which has been.
See, this, what is this? This part. This note sheet 32, it speaks of what, Mr. Gautam?
My lord?
That note sheet 32.
My lord, what I said is, my lord, this is.
No, you see, we could follow what you said.
I am
Okay.
more concerned about
But then
para.
before that, what we are asking,
My lord.
what is the finding recorded at para 65 and 66?
My lord, my entire thing is, my lord, what am I contesting here is, my lord, these are internal communications. When I file an appeal, my lord, the statutory appeal has to be dealt with by the Director General himself. Now, what conspired internally, my lord, that is not an order. The order is which is supplied to me. Now, that order is signed by the Chief Law Officer. But here, what is produced before you is that, my lord, final orders may be passed. Now, the question is, where is the final order, my lord, and who will issue the final order?
That is why, before that, have you seen paragraph 66 and paragraph 65?
Well, I have seen, my lord, he is saying that
so these are not in connection with your appeal.
My lord, they may be, my lord. They may be.
So you are not sure.
They may be.
Your contention is not that this your appeal was not at all considered or something like that, or is it something like that?
My lord, my contention is very simple. I say that, my lord, my final, that statutory appeal, the post confirmation should have been dealt with by the Director General. It has not been dealt with by the Director
Which date
General.
you preferred your appeal?
My lord,
Is it on 4th August 2021?
yes, my lord. Right after my pre-confirmation finding was given.
What is the date? Let us see, because it appears that in this note sheet.
4/8/21.
4/8/21 only, my lord. And thereafter, after almost a period of 6 to 7 months, my lord,
Anyway, so it means the record reveals that it was considered. Anyway, please supply us a copy of this note sheet. Yes.
I have a copy, my lord. I can have it.
Anyway, okay, we'll take into consideration here.
So, what my case is, my lord, is that in fact there is a judgment of the division bench of this honourable court also, honourable High Court, which I have placed. I'll place it one more time.
No, probably it is there. I think this is it.
Pradeep Kumar Hajong, my lord.
Is it that this compilation?
My lord, I have argued this matter quite a number of times. I don't know whether it's there. I'll give you one more copy, my lord.
Is it the?
That is my paper book which I have prepared, my lord, to assist.
No.
the court.
There is a separate compilation. Is it not supplied by you?
Well, I think that I earlier also on earlier occasions have argued. I don't have a copy of that particular one with me right now. My lord. Just this one I am placing right now, my lord. Pradeep Kumar Hajong.
Yes.
It's a very short judgment, my lord. Here it was very similar to what I am arguing before this court, my lord. If I can come to paragraph 6, my lord.
Yes.
Page 2. When a remedy in the nature of an appeal or revision or review is provided for by a statute, the appellant or the petitioner seeking revision or review has a right that his grievance be appropriately assessed. Such grievance may be seen to be appropriately dealt with only when it appears that the authority before whom the matter was carried applied its mind to the matter in issue and dealt with the grievance in accordance with law by passing a speaking order. Of course, the statute which gives may also take, and it's perfectly permissible for the statute to require even a non-speaking order to be passed. However, non-speaking order would be an exception and not the rule. Thus, unless the statute which grants remedy expressly provides for a non-speaking order to be passed, the matter has to be dealt with by a speaking order. Since the writ petitioner's petition under section 117 clause 2 of the said act in this case does not appear to have been appropriately dealt with in accordance with law, the writ petition succeeds and the order communicated to the petitioner by the letter dated June 22nd, 2015 is set aside. The petition will be considered by the present Director General in accordance with law by keeping in mind the observations above. So, well, here also the similar.
Just tell us what was the order which was communicated to you.
My lord, a detailed order was communicated. I'll take lordship.
Is it not the same what is reflected in the note sheet of this thing, this note 33 or what is that, what we have perused just now? Is it the same or,
It may be the same, my lord, but that is not my argument. My lord, if I may give
whether
an,
it is see, this court wants to know whether it is same or not.
it will be similar to that, my lord. But what I say
See,
is
similar and same is not the same thing. Whether it is same or not.
exactly the same. I cannot say now. Well, I perused it almost a month back, and in between, my lord, learned senior was not well, so some time was sought. So I don't exactly remember it was same or not. But I just
what is that in your in this paper book? Where is the order passed by the appellate authority?
I'll just take you there one. Lordship 401. No, well, not 401. Just give me a moment. 427. 427 starts from 427 in my paper book, my lord, and ends at page 438.
Oh, 27.
427, my lord.
Yes. Just a minute. Just a minute. This is order by the appellate authority, isn't it?
Yes, my lord. Said to be the appellate authority, but I contest that because it is signed by the chief law officer.
That is okay. You are saying that this is not now.
No, no, no. It cannot
That is what the case is. Now, what we have seen in this thing is not the same order. It cannot be. Because the earlier order is on only of 1 page, 2 page. The record says that it is.
The conclusion is same, my lord. If I can just place a copy, my lord.
No, no. See, conclusion is same and the
findings,
determination
only
is something
the findings
different.
over there, they have
Just
given
because
the
the
findings.
superior officer will tell you, you do this, you should do it, and then you
No,
say
it's
that
not
this
that,
is
my lord.
compliance of this.
If I just, lordship, I can read together with the.
Well, I'll just one
With the
small
record,
argument
my
I'll
lord,
make
and
before learned senior will say. No, what I have been trying to, my lord, impress this court is from the beginning is that, my lord.
No, no. This is
My
a copy
appeal-
you have given from where?
From the record, para 65, 66.
So my argument, my lord, what my argument is,
Just
lordship.
a minute. Just a minute. One second. There's this note sheet. There is an overwriting on the thing and the numbering and all, Mr. Dr. Majiga. Note sheet number 31, 32, 30, 29. This seems all these are overwritten, isn't it?
Yes, yes. His number is already.
Well, in fact, a copy can be provided to the court and to me also, my lord, at least. But there's no bar. There's no bar for me to.
No, that is an order which is basically, I think.
I was allowed to peruse, but then I could not go through the entire record because it's a voluminous record.
Yes,
And
you
well,
can-
this is the crux of the matter. In fact, my lord, here.
Dr. Majiga, supply him a copy which you have supplied me to the court just now.
My lord.
Let him see whether there is a difference or not.
So what I am saying, my lord,
Apparently,
is that-
there seems no difference.
my lord, that has been placed now over here.
Just you can
I
see
has
it for
become
the time being.
I.
This is a court's copy, right? You did just.
But that has been supplied now.
But you're given to peruse. You got to take a picture also.
My lord, my argument again, my lord.
Please return it back to us. Just once, my lord.
I'll just see. I'll just peruse once. My lord.
You can take Dr. Mojiga's copy for the time being and just see it. Just give it. Just go to peruse it.
The last page is required.
One of you can go. One of you can go. I think it's it. You just compare, Mr. Gautam, and just tell us whether there is any difference or not. If you find any difference. Anyway. Yes.
So, well, I'll just complete my argument. No, what is my argument is, my lord. The law provides a thing to be done in a particular manner. And that thing has to be done in that particular manner only or not done at all. Well, there we have judgments of the Privy Council also, which have time and again been placed before, even before the Supreme Court. Your Lordship will remember, I believe it's Nazir Ahmed's case. I don't have it with me right now, but I'll place it with. Now, if the law provided for the Director General to dispose of my appeal, why was it not disposed of by the Director General? And what have I lost, my lord? I've lost my job. I've been sent to prison. But the authorities have not dealt my post-confirmation appeal appropriately. So only by the chief law officer signing and by producing these notes, my lord, will that wrong be rectified? And when there is already a judgment of the division bench in this regard. Of course, in that particular case, my lord, it was a gruesome murder. So it was sent back for the same thing to be rectified. Another aspect of my argument, my lord, whether my learned senior will agree or not, my lord, there is something called the doctrine of merger. The finding of the court after the appeal has been dealt with has merged with the appeal. Now, when the appeal has not been appropriately dealt with, my lord, my submission is that, my lord, the finding on sentence should also go. Because in court-martial proceedings, in BSF proceedings, my lord, it is for the authorities to deal with the matter in a very fair and proper manner, and whatever has been given by the statute, that has to be followed to the T. Because the scope, again, it's not a normal criminal appeal, my lord, where, my lord, I come before the High Court and I read the evidence in every single case. Of course, the court does provide. In some cases, I may be allowed to go through the evidence. But when I file a writ petition against the finding before this court, my lord, my limited bracket is, my lord, whether the procedure was conducted properly or whether, my lord, the entire rule was followed or not. That is why, my lord, the bracket for them, my lord, the reason why, my lord, the authorities have to give me a very, very fair trial. And that has not been given to me. This is one aspect, my lord. The other aspect is, Rule 86 of the BSF Act provides for dropping of witnesses. My lord, witnesses in any proceedings can be dropped. My lord, even in criminal trials, they can be dropped. But here what this Rule 86 provides is, my lord, if you are willing to drop a particular prosecution witness, which you have examined earlier, and you do not wish to bring him for whatever reasons, you give me an opportunity so that I can bring him as a defense witness. In this particular case, my lord, of all the witnesses, there is one particular witness, PW8, who in his record of evidence has clearly stated that I knew for a fact that these two people were having an affair. And I have time and again scolded the writ petitioner not to engage in something like this. You will get into trouble later on. That particular witness, PW number 8, who is PW number 8 in the record of evidence, was dropped. I was never given an opportunity to call him as a defense witness.
Where do we get that part, that PW8, where it is reflected that he was a witness?
My lord, I will take lordship to that particular page.
Is it page 120?
Page 120, my lord. Page 120. If I may read, my lord, if lordship is in page 120.
Yes.
Prosecution witness number 8. May I, my lord? Swapnil Saste, my lord.
Yes.
I number so and so, Constable Swapnil Saste, 58 Battalion BSF, after being duly affirmed, state that I number such and such, Constable Swapnil Saste joined BSF in the month of 15 April 2011 and joined 58 Battalion BSF in the month of 28 February 2012. Presently, I am performing the GT duties along with painter in 58 Battalion BSF.
Now, this is a statement recorded by whom?
Well, by the BSF itself, my lord.
At the time?
At the time of preparing the record of evidence, my lord, ROE. On 30th 11/2018, I was detailed to perform painter duties on 26 Battalion BSF, and their inspector of AIA was nearby. At about 900 hours in the morning, I left for 26 Battalion BSF by 58 Battalion BSF movement order for painter duties at 26 Battalion BSF. I hereby produce the copy of the movement order, which is shown to the accused and will be received through IPP Exhibit M15. I met Constable Bhan Kanaya Ramhari in the campus and told him I am going to 26 BN BSF for performing painter duties over there. for a few days. After that, I reached 26 Battalion BSF and started working in armor workshop in quarter guard of 26 Battalion BSF. In the evening, when I was performing work in quarter guard at around 17:30 to 17:45 hours, when it was a little bit dark, Constable Bhankanya Ramari came to me for inviting me for dinner at his home, as he was residing in the campus along with his family. After that, we had a little chat and I declined his offer for dinner and told him that we will have it next time. And Constable Bhan Ramaya Kamari left for the place. I, along with the ARMR, I don't know what this means, of 26 Battalion BSF, worked there till 19:30 to 19:45 hours, and then I went to the barrack, had my food, and took rest. Next day, on 31st/11/2018, as per routine, at about 7:30 hours, I reached quarter guard of 26 Battalion BSF to resume my painter duties. After some time, I receive a call from CT Bhankanya Ramari, and there is some problem. There is some problem, and you please come to my house. When I reached in the vicinity of the house of Constable Bhan Ramaya Kanaya Ramhari building, I found that Constable Bhan Kanaya Ramari, along with Constable Varun Kumar and his wife Srimati So and HC Sunil Kumar, were discussing some matter over there. When I reached there and asked what the problem is, I came to know that Constable Varun has come to know about the affair between Constable Bhan Ramaya Kanari and his wife Srimati So through CT Bhan Kanaya. I, along with HC Sunil, tried to tell him to sort the matter out here, but Constable Varun Kumar was adamant that he will report the matter. So, my lord, this particular witness had something totally different to say. In his cross also, my lord, he reiterated the same thing. But unceremoniously, my lord, he was stopped. And I was never given an opportunity.
But he's not witness to the crime, isn't it?
No. He's not witness to the crime, my lord. He's not witness to the crime. Well, here everything is based on sole testimony. Sole testimony of the victim, nothing else. But even so, my lord, even there, my lord, I should have been given an opportunity of calling this witness as my witness. If I may read Rule 86, my lord, 86 of the Border Security Force rules. Rule 86.
Yes.
May I read, my lord?
Yes.
Dropping witnesses. The prosecutor shall not be bound to call all the witnesses against the accused whose evidence is contained in the record of abstract or evidence, nor a witness when he has notified the accused that he intends to call under Rule 85. But if the prosecutor does not intend to call such witness to give evidence, he shall either tender him for cross-examination by the accused or give the accused reasonable notice that he does not intend to call the witness, and that the accused will be allowed to communicate with him and to call him as a witness for the defense if he so desires and if the witness is available. Now, my lord, may I ask my learned senior and law officer over here, what was the reason for dropping this particular witness?
No, forget about the reason, but the thing is that,
my lord,
they have not examined it, and that
they have not.
So that is a vital right given to
absolutely, my lord, absolutely. Because this, my lord, this at the end of the day shows that, my lord, I have not been properly dealt with in the trial itself. Not only at the appellate stage, even in the trial stage also, my lord, I was not given a proper opportunity. These are the two contentions which I have, my lord, primarily when it comes to, my lord, the trial. But, my lord, if we go through the evidence also, the allegation here is that, my lord, the wife of the complainant, Constable Varun, could not speak properly. She had a hearing and speaking problem. When she is medically examined before the doctor also, she says that the doctor could not communicate with her. Doctor needed help to communicate with her. But interestingly, when she came and deposed before the BSF court, she could freely communicate. The allegation is that, my lord, the writ petitioner raped her, and, my lord, thereafter the matter was reported. Initially, the police, an FIR was filed. After the FIR was filed, charge sheet was submitted, and under the, my lord, the prevalent laws, my lord, the BSF has the right.
You are making a submission without referring to the things, so this will be difficult for this.
No, well, I'm just giving a gist of what the evidence is, my lord. The gist of what the evidence is.
We'll continue after lunch break.
My lord. My lord, we can continue on Monday, my lord, because I am a little under the weather also, my lord. You can do it on Monday, my lord.
Your voice says so.
Yes, my lord.
I do not know what about Monday.
Or tomorrow?
Tomorrow I have. Please. On Monday, my lord, because I think I'll have to read a lot of evidence also.
Mr. K.C. Gautam, learned counsel appearing for the petitioner, has commenced his argument, but could not conclude the same. Yes, sir. Yes, wait for by the parties. Just next slide. This is matter on. Give Monday's date for further hearing. 11. For further hearing. Yes.
Apply.
This compilation has not been submitted by you.
Well, even this matter was heard a number of times. Well, I'll submit another
No,
compilation.
whether that is, if it is there, then you do not have to.
I'll just check, pilot, if the same compilation
Because
is
we
there.
do not want to keep so
Pilot,
many
absolutely.
things. You see, this becomes.
I will just check, pilot, if the compilation is there, then I'll rely on the same compilation. Just see.
Keep this inside. Yes, for the, how many meters are there? Another 5.
Watch out.
Lordship, I filed my substitution petition, which was allowed by the order dated 21/07/2025.
Your substitution was allowed?
No. Order to file my substitution
Okay, you
petition.
are allowed to file the application.
Application, yes.
I may be allowed to file a reply, Lordship.
Lordship, in this matter, the government counsel dealing with the case due to personal difficulty, Ms. A. is unable to appear, my lord. Of course, she had appeared before on the other bench, my lord, pertaining to the same parties, my lord, for cancellation of bail.
You want to file your objection? Yes, sir.
Lordship, may I take Lordship attention, Lordship? Lordship, here in this case, after my client expired and after seeking due permission from the court to file an appropriate petitions, a complaint has been filed before the Bar Council, Lordship, against me. I came to know that there is a complaint filed in the Bar Council by the accused person, stating that I have appeared throughout the case without wakalatnama from the concerned party. Other accusation I am not yet aware of, Lordship. Lordship.
So what this court can do at this stage, so far as the
Even I am not privy
proceeding before Bar Council is concerned?
Even we are not privy to that.
Yes, Mr. Paul, you want to say something?
Just assisting my lord's village in the issue. My little friend pointed this out. I think this issue had come up before my lord's village. And what is unfortunate is that there is this new practice, lordships are aware that this in litigation between the parties, now councils are being drawn in. Young counsel, I can only speak as a member of the bar, that there could have been maybe something for my little friend's side. That does not necessarily call for a complaint. I think my learned friend can use his good offices to ensure that this matter can be put to rest. The difficulty is, and I can say this, that as a member of the bar, and also from the Bar Council, once it officially goes on record that there is a complaint, my lords understand, then a lot of ramifications for a
What this court can do, just tell us.
I would only pray, my lords.
See, court has not made any observation, nothing.
What is even more unfortunate is, after your lordships have passed the order on 21st, which is, I have seen the order of 21st, your lordships have in a way, tried to put this matter to rest. I think this was brought to the notice of this Honourable Court. It was sought to be brought to rest, where my
once you have allowed her to file the substitution application.
In my respectful submission, my lords had allowed this matter to be resolved. But I don't know,
But then, so far as if there is at all any complaint before Bar Council, you cannot just interfere.
No, we are not seeking an interference. My friend, when she informed me, I said it is our firmest duty to first inform this Honourable Court. And after that, if my friend is here, these matters can be resolved. The unnecessary
You do it actually.
In fact, I was just informed today morning that this is happening.
If he is also not aware, then
it's unfortunate, because there seems to be this new trend that is coming to vogue. My lords were sitting in the division bench the other day, where my lords interfered in a certain matter.
Anyway, we cannot pass any order.
I am not, my lords, I can only say that this matter can be resolved amicably. It should not go on record. Young lawyer, unnecessarily, my lords, there is something, it would have larger impact.
No, we did not see, this court never expected that this would go to that extent. See,
I have seen the purport of my lord's order on the 21st. I thought that settled the issue.
I think we have not proceeded with that thing.
My lords, as a matter of fact, permit the filing of a substitution application. The matter should have ended over there.
See, even the prayer allowing her to file a substitution application was opposed, but then we allowed it.
Absolutely, my lord. Which, as I said, my lords have found a nice way of putting that matter to an end. After that, there was no reason that this should have escalated to this kind of a situation.
No, she has now this thing.
After the order. The unfortunate part is, this is filed after this order. as we understand, my lords, as what we've learnt, my lords, all along is that matters should be fought out on merits between the parties. Simply because, my lords, some counsel is representing somebody.
No, but then there is nothing against her in this court's order sheet.
No, my lords, there's nothing has come for my lords. My lord has settled this issue. This was probably brought to the notice of this court, my lords, that there was some appearance without a wakalat. My lords permit filing of a substitution application and the matter ends there. After that, to go and file a complaint, my lords, on some issue over which my lords have already passed this order, settles this issue. My lords had put a closure on this.
See, we have not initiated anything. There is no question closing. See,
No,
the thing is that if you see the order dated 1/7 passing this thing, the court has already, it was brought to the notice of the court that you see like appearance was made without submission of wakalat. But then you see like if you see this subsequent order, whereby she was allowed to file a substitution application.
Which is what I'm saying, my lords.
That is why.
My lords had finished the matter. It ends over there. After that, my lords, I don't know, understand after these two orders.
You see, whoever takes up the matter at Bar Council definitely will understand that part. If rightly or wrongly, if anything is initiated, we cannot help it. You see, like that has
the difficulty is, well, the difficulty that, as I had expressed, it will officially go on record. It's a separate issue, my lords, that it may not culminate into anything, but it officially goes on record. I think my learned friend can use his good offices to put this matter to rest. It should not, well, I have always stood for this, that these matters should not, be allowed to continue. It is a very wrong practice. We shouldn't indulge.
Also, because what they are also saying is that there was probably some, because it was directly sent by the petitioner concerned.
So anyway, probably you can use your influence and just see.
It should not be, it should not come to this.
I understand, I appreciate it, Lordship.
Probably your colleague you see. And if there is no bad intention involved, why should we?
Absolutely, Lordship. Whether she files a wakalatna, I will not win the case on that. So,
Well, the matter should be fought out on merits rather than. Anyway, I am obliged, Malad. I am obliged. I just thought, Malad, to assist your lordship.
We can understand your concern, Mr. Paul, but then only thing is that we cannot pass a judicial order.
No, Malad, I cannot press for that.
Directly them to, you say, like withdraw that complaint and all.
I should not do that also. But I thought, Malad, this is something that we should not.
Allow me to just.
I'm sure my learned friend will take care of it. Please. I'm grateful.
Please.
I'm grateful.
In the meantime, I'm only praying to file a show cause in the, as far as the merit is.
In the criminal miscase, see, you want to file your show cause in the substitution.
In the show.
Yes.
In the substitution.
Yes, in the miscase number 7 of 2025. Just say this is an application. Praying for substitution of the
respondent 2.
In the miscase, why you say petitioner? Substitution, you see. See, while preparing petition, you take care. Somewhere you mention petitioner, somewhere you say applicant. Now that is a problem. Even come to your course title, you see, you'll find. The first part says petitioner. Okay, now this applicant.
This applicant,
I
petitioner.
think she mentions the main case.
Okay, just say this is an application. Praying for substitution of applicant in place of the deceased. Respondent number 2. Stop. Mr. Deb, learned counsel appearing for the respondent. Respondent number 1.
Respondent number 1 is State of Meghalaya.
In the miscase, I'll be respondent. Although the state is not, there's some.
No. Where is the respondent in this miscase?
Triple C versus State of Meghalaya, and in the matter of.
Yes. So where is the respondent?
Should have been just number 2. I believe.
You are not a party here.
Because below my name is ... respondents. Sri Gopal Krishnan Gaur. In the just before the recitals.
Page number 2. Page number 2.
Yes.
There is some defect, Lordship.
There is nothing.
Srimati Dimse K. Sangma, so and so applicant. In the first page.
And in the
next
second
page versus State of Meghalaya, represented by public prosecutor.
And
in the matter of Gopal Krishnan.
In the miscase, you are referring to miscase.
Miscase.
Where is that? Just see it.
Kindly see the second page.
Page number 2.
Or if your Lordship is pleased to
Page
come.
number 2 starts with versus State of Meghalaya represented by so and so, and in the matter of
Gopal
Krishna Gaur, late so and so, resident of so and so. There is no ...
On the right side,
State of Meghalaya, represented by the public prosecutor.
right, and respondents.
Thereafter, and
Ideally, it should have just been 1 and 2.
This is not the way you prepare a petition. I do not know nowadays office why they accept this kind of thing. See,
I see, Lordship. That
where is the ... and all?
in my copy, Lordship, that perhaps they have corrected it subsequently in the
Lordship,
registry.
it's Gopal Krishna God is the.
But here
Lordship, the
also
word
it is not
respond-
correct because this has become Gopal Krishna versus State of Meghalaya. In the Miss case, there's.
This is a problem. You correct it, madam.
Let them file a fresh one, Lordship. We'll file a quick reply to it.
Lordship, I'll collect the cost title, Lordship.
Should have been number 2.
Just say there appears to be some mistake in the cost title of this application. In the miscriptive, just say. Okay, just erase the other part. Just only say there appears to be. Just say the learned counsel, opinion for the applicant, submits that there is a mistake in the cost title of the petition. And prays for permission to correct it. Just say the petitioner is allowed to make necessary correction in the cost title list after 1 week.
So the corrected copies may be supplied, Lordship.
Definitely,
Of course,
that has to be. That has to be.
Yes, Lordship.
Because now also that copy was different.
Do not know how we will correct it here. There is no space also. How we will do it?
I would suggest to file a fresh one. I think it would be. Because already certain corrections are made in your Lordship's copy.
Lordship,
Again,
Things will become messy if you make any correction here. We do not know how we will make correction here. There is no space at all. We withdraw this application, file a fresh one. This is totally your mistake.
Lordship, I can make the correction like Lordship. The word respondent has to be added.
Where? Party's name is not appearing. Where you like?
And in the matter of it.
And
looks
in
like
the matter.
State of Meghalaya versus Gopal Krishna.
That is what.
Instead of just writing number 2.
You withdraw this, file a fresh one. One prayer made by the learned. Just say on the prayer of. On the prayer made by the learned counsel of the applicant. This miscellaneous application stands withdrawn with the liberty to file afresh. You do it. And the main petition is slated today for the.
Main petition, Lordship.
It's fixed for.
They were supposed to file an objection. They had prayed for time.
Lordship,
earlier.
once the substitution is allowed, then
Just when you will file that other application?
Lordship,
When you
One-
file a fresh application,
1 week, Lordship.
just say in the writ petition, you just say list after 1 week. Not in the writ petition, the criminal petition. Criminal petition 47 you say restoring and criminal miscase 71 will stand withdrawn with liberty.
Item 20.
Obliged.
Yes.
May please, Your Lordship. Your Lordship, this is an application, Your Lordship, to quash and set aside, Lordship.
Lordship, learned DSJ is on legs, Lordship, before courtroom number 2.
So what is to be done?
Okay. Lordship, the petitioners may start.
And by the time petition officials, if you are not there, then we will close the hearing. If Dr. Mojika is not there,
Then I pray for accommodation, Lordship.
See, we'll not waste time by these things. Like you hearing and then thereafter you make her take all the trouble and then you just later on you say like you want adjournment.
Lordship, after 1 week.
Yes, Miss Colony, you are appearing?
My lord, the issues with regard to CBI investigation, madam. So we will be having our own argument, madam. However, madam, CBI has to first reply to the case.
You have to wait for Dr. Mojige. Just one prayer made. After 1 week, it is not possible. It will go after 2 weeks. Just one prayer made on behalf of Dr. Mojige, London DSGA. This is matter after 2 weeks. If you have difficulty, you inform the other side counsel before, at least they will not have, they can do their other work also. Instead of wasting time here. Nothing more.